So good morning, Verlyn. Thank you so much for meeting with me today and being willing to take time out of your busy schedule to talk a little bit about your career and how you made your way into dispute resolution.
Oh, it's a pleasure. Thank you very much for arranging this, Ellen. I really appreciate it.
So I've taken a look at your very impressive resume, and I see that you have begun your career, as so many, working as counsel, and then sort of transitioned into your neutral work. And I'm wondering if you can tell me a little bit about what drew you to the field of dispute resolution.
Well, I actually came to law in a sort of a little different way. So to earn money to pay for my law school tuition, I worked as a court reporter. And after observing the numerous cases being litigated, I thought there has to be a better way of settling disputes. So when I was in law school, they offered the first commercial dispute resolution course. I signed up and I loved it. Right? It showed me things that I thought, maybe this is what the court should be doing. However, like many newly minted lawyers, after my call to the bar, I worked as an advocate. But I was fortunate to have those skills in place. So I was able to use the skills that I learned in DR to get great results for my clients.
Talk a little bit about how the skills and knowledge that you gained working as an advocate help equip you to conduct the mediations and the arbitrations that you do now.
So a skill that every advocate, of course, has to learn is to manage client expectations. Yeah? We are told it's something we should do, but very rarely are we told how to do it, right? So, the usual research the damages, look for similar case, similar facts, that sort of thing. However, as I said, I was already equipped with the understanding that it's not the position taken by the parties, but the interests underlying those positions that can lead to satisfactory resolutions. So I learned how to listen empathetically, to hear what the real issues are, and how to ask questions to clarify those issues for the parties, for lawyers, and the judge. Right? In other words, I was honing my skills as a mediator. Right? And as far as arbitration, while it is different, of course, to litigation, from the many judges that I encountered over the years, I learned how to be respectful, impartial, how to assess evidence and to apply the law and to render well-reasoned decisions. So it all worked for me. I was very fortunate.
I'm now going to sort of ask you a little bit about what you like best about these two different procedures, what you like best about arbitration, and then also what you like best about mediation.
I like being part of, as far as arbitration is concerned, I like being part of the process that helps parties to save time and money so they can get on with running their businesses, carrying on their careers, and living their lives while still having access to justice that is fair and impartial. I think that is really important. And as far as being a mediator, what I like is to give the parties the tools they require to resolve their own disputes, right? Sometimes that's asking them questions so they can develop a better understanding of their own interests and the other party's interests. And sometimes it's reframing a statement that could push the parties back from contending and going off into litigation. I also really like to help the parties to find creative ways to satisfy both of their interests.
So it's the sort of opportunity to forge creative outcomes that you really relish in
I
mediation.
really do.
Okay, so now I'm going to ask you the flip side. Are there any challenging aspects of both of these processes that jump out at you? And then what do you do when you encounter those challenges?
Yeah, and in mediation, it's the people who come to mediation not knowing the process, or even if they do know the process, try to manipulate it, thinking that, and really what they're thinking about it as is basically a step on the way to arbitration or litigation. I then would point out to them the benefits of coming to their own resolution of the dispute, because as I say very often, no matter how strong you think your case is, and I used to say this to clients, no matter how strong you think your case is, if a judge or arbitrator decides the case, decision could go against you, right? Better you handle it, you decide what resolution you're going to have rather than putting it in the hands of somebody else, right? And for arbitration, it's the unprepared advocate who will introduce extraneous evidence and law. That really bothers me because, of course, the whole idea of arbitration is to save time and money and to, of course, have fair and just results. So some of the advice that I would give to representative, to counsel, is, first of all, and this does happen, believe it or not, you think it wouldn't, is to be respectful of the panel and other counsel, right? Your reputation is the most important thing you have in this business, and you don't want to tarnish it, right? And my second bit of advice is, look, this is arbitration, not litigation. We are going to be efficient and cost effective from the preliminary hearing down to the final award. So things that counsel can do, for instance, is before the preliminary hearing, as much as possible, agree on matters. Don't relitigate things or litigate things that are not really in dispute, right? So if you can agree on things like date, if there's going to be a motion, the dates that it has to be, if there's going to be discovery, who's going to be discovered and for how long, hearing dates, witnesses, are you going to have experts? Can you agree on maybe a couple of experts instead of bringing 3 or 4? Because I'll rule on the 3 or 4 and I'll see that maybe you don't need them, right? And if it's possible, agree on a statement of fact and statement of law. It can be very helpful. It helps to shorten matters. Know your case. It sounds almost trite to say that, but it's actually sometimes annoying to see people stumbling around. They ask a question, they're stumbling around their materials because they don't know where to find it. Somebody else in the office has put it all together and they know it's there somewhere, but they don't know how to find it. Also, you don't have to bring 20 points to prove. Figure out what are the really important elements of your case, and bring those forward. State your case on those. Research. So make clear arguments. that makes sense, and you'll be, very likely you'll be successful. And please, especially in these days of virtual hearings, please don't dump your materials on us without some form of organization that is simple to follow. There is nothing more annoying than you're telling me, oh, it's, the document dated so and so, and I have no way of knowing where it is because you haven't sorted the materials. You haven't gotten together, for instance, with counsel on the other side to, agree on the documents and to put them into some kind of order. So sorry, I went on a bit there but it is these are some of the things. I don't think I'm alone. I think a lot of arbitrators will probably be telling you these very same issues.
I have heard some of these comments about what counsel can do to enhance their likelihood of success in front of an arbitration panel or a sole arbitrator.
Yeah.
So what if you had to identify one distinguishing feature of how you approach arbitration or your role as an arbitrator, what would it be?
Well, my I would think that it's my procedural, interpersonal, and decision making and award writing. Those are my really good skills. By procedural, I mean that ability to conduct a hearing that is fair, that is flexible, and effective. Right. So you have procedures in place. You control the hearing. That's what that's what your job is. And of course, if you can't make a decision, then you shouldn't be doing the job. It's but it's amazing how many people at the end of a hearing, an arbitration, oh, what should I do? Right. If you have questions, you should have been asking them while the hearing was going on. And of course, it all comes down to an award that is well reasoned, that sets out all the things that that are needed for the parties to understand what you did, how you reasoned, how you got there.
I'm going to ask you the same question about mediation. What's your distinguishing feature as a mediator?
I think my knowledge and experience in mediation, along with my ability to bring calm into even the most charged situation, while still helping the parties to think creatively and to problem solve, right? To help them to not just look at the position they're taking, but to understand that disputes are more than the position. There's a reason why you're taking the position, and to find out those reasons and to think about them, and for the other side too. And it's that will help us on the way to getting the parties to resolve disputes. So, and I'm also very tenacious. When you think you can't quite make it, maybe let's think about it. Let's turn it around. Let's turn the problem around and think about it again, right? You're in mediation because you want to resolve the issue, right? That's why you came. And my job is to keep you there, to help you to get to that point.
Sounds like you don't give up easily.
Not at all.
So, back to arbitration. I know that there are different views among the arbitrator community. What are your views on discovery and dispositive motions? How do you help counsel secure the benefits of arbitration, which is supposed to be sort of speed and lower cost than the litigation process?
So look, if a discovery is necessary, I'll permit it, okay? But if the discovery is being used to prolong the process, I have no hesitation whatsoever in curtailing it or refusing it, and reminding counsel that the main goal of arbitration is efficiency, right? So while also dispositive motions can accelerate the resolution of the case, the argument for allowing them have to be, in my view, persuasive, because you're asking the arbitrator basically to extinguish the other party's right to a hearing on the merits. And so I expect really good arguments about why I should do it. However, if a party does persuade me with submissions from the respondent that there is no merit to a portion or all of the claim, I have no hesitation in dismissing the claim or portion of it, right? This is, of course, a part of promoting the efficiency that we have in arbitration.
Thank you. All right, last question. I note that you have worked for many years teaching dispute resolution in a variety of contexts, and I'm wondering, how does your work as a professor inform your work as a neutral? And what's your favorite thing about the teaching that you do?
The way I look at it is my practice and teaching feed off each other, right? In my academic work, I'm working with graduate students, so they are challenging my research and my ideas, right? I love the give and take, the respect for ideas, the need for patience that comes with teaching. And also, teaching forces me to be empathetic and to see other ways of being, right? That then refines, if you will, the ideas and skills that I bring to my DR practice. Right? At least half of my classes are international students, and that requires me to be culturally intelligent. Right? In other words, I'm always learning. I'm don't think I'll ever reach the point where I'll say that I'm culturally competent. I'm not. I'm constantly learning, so I'm developing my cultural intelligence, right? I understand that I have to embrace difference and to bring that worldview then to my practice, right? That anyone could retain me as an arbitrator or mediator. And those points, those skills that I've learned, those ideas that I've developed do help me, right? And of course, because it is my ethical duty as a practitioner to pass on my knowledge, I do that by teaching the next generation of arbitrators and mediators. I love teaching. I love practice too. I don't want to give up. Don't ask me to pick between my children. Okay. Yes, I can't.
You don't have a favorite child.
Oh no, I need them both.
Beautiful. All right. Well, thank you so much. I think that the CPR community will be very much enriched by our discussion, and I thank you for giving of your time to us today.
Thank you so much, Ellen. It's been a pleasure.